Good afternoon, World Record. In case 2025-0090, said matter is captioned in the Court of Common Pleas. It's in the Criminal Division of Adams County. The state of Ohio is the plaintiff. Brian Moser is the defendant. It's noted that the matter returns to the court docket on the 24th day of March of 2026 for purposes of sentencing. The state of Ohio creating in the form of Mr. Tyler E. Cantrell, Assistant Prosecuting Attorney of Adams County, Ohio, Mr. Aaron Haslam, Prosecuting Attorney of Adams County, Ohio. Also present is Mr. C. Nicholas Ring. Mr. Ring is counsel for the benefit of the defendant, as well as the defendant, Mr. Brian Moser. Sir, you're Brian Moser?
That's correct.
Mr. Moser, your date of birth, please.
May 16th, 2002.
Mr. Moser, as you're sitting here right now, sir, do you feel that you're under the influence of any alcohol, drugs, prescription medications, or any illegal substances that would cause you in any way to be confused about today's sentencing hearing or unable to assist Mr. Ring should he need your assistance? Very well. The record shall reflect the court has provided the pre-sentence investigation summary report to both counsel of record. State, I'll start with you. Have you had an opportunity to review same? And if so, are there any additions or corrections?
We have reviewed it, Your Honor. We have no additions or corrections. We're ready to proceed to sentencing.
Thank you. Mr. Ring, same inquiry.
It appears to be correct.
Thank you. State of Ohio, you wish to be heard.
Yes, Your Honor. In this matter, the parties have a stipulation. We would ask the court to follow that stipulation, and then that stipulation is as follows. In regards to count 4, that the defendant be sentenced to a term of 10 to 15 years in prison. That's to run consecutive to count 8 of 30 months, to run consecutive to count 10 for 30 months, for a total term of incarceration of 15 to 20 years of incarceration.
Are there any of the victim's family that wishes to be heard?
I have talked to the father is here, Your Honor. He's just here for support and to see this through. He did not want to speak to the court.
Very well, thank you. Mr. Ring?
Your Honor, Mr. Cantrell has stated the stipulation correctly.
Mr. Moser, under Criminal Rule 32, you're entitled to make a statement. You're not required to make a statement, but you're certainly entitled to. Is there any statement you'd like to make, sir?
Yes, sir.
Go right ahead.
I just want to deeply apologize to the family. And I just want everybody to know that it's going to traumatize me for the rest of my life. What happened was a good accident. And I'm going to see mental health. And I'm never going to hurt anybody.
Thank you. Submitted, counsel.
Yes,
The court notes that on March 24, 2026, the defendant's sentencing hearing was held pursuant to Ohio Revised Code Section 292919. President Court was defense counsel Mr. C. Nicholas Ring, Assistant Prosecuting Attorney Tyler E. Cantrell, as well as Prosecuting Attorney Aaron Haslam, as was the defendant Mr. Brian Moser, with Mr. Moser being afforded all rights pursuant to Criminal Rule 32. The court has considered the record, the oral statements, and the victim impact statements, as well as the pre-sentence investigation report prepared, further considering the principles and purposes of sentencing under Ohio Revised Code Section 292911A, which sets forth that a court that sentences an offender for a felony shall be guided by the overriding purposes of felony sentencing. The overriding purposes of felony sentencing is to protect the public from future crime by the offender and others, as well as to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden upon the state or local governmental resources. To achieve those purposes, the sentencing court shall consider the need for incapacitating the offender, deterring the offender and others from future crime, rehabilitating the offender effectively, as well as making restitution to the victim of the offense the public will vote. Further, this court must and will balance the seriousness and recidivism factors of 292912 and notes that it would not sentence Mr. Moser or any other defendant before this court based upon the race, ethnicity, gender, or religion. The court does find that the defendant has been convicted pursuant to a voluntary plea of guilty in count 4 to involuntary manslaughter in violation of Ohio Revised Code 2903.04A, that being the felony of the first degree. In amended count 8 to child endangering in violation of Ohio Revised Code 2919.22B3, that being the felony of the third degree. And in count 10 to child endangering in violation of Ohio Revised Code 2919.22B3, that as well being the felony of the third degree, all of which subject to Provision A of 292914 of the Ohio Revised Code. The facts of the case, July 1st, 2025, the Adams County Sheriff's Department was dispatched to a child that was not breathing, a 2-year-old female. Upon arrival, Sergeant Phillips asked the male standing at the door where the baby was at. That being Mr. Moser, he advised upstairs. They started up the steps. At that time, Sergeant Walters was carrying the 2-year-old down the steps. Sergeant Walters then laid the baby down to start chest compressions. As latch lights pulled up, Sergeant Walters then ran to the squad with the baby. There was also Deputy Grooms, who was also present, who was also part of the interview process. The court found from the police report that after being Mirandized, that the Adams County Sheriff's Department and their respective agents that were on scene did a very thorough job of the inquiry of the parties at that time. The things that from that stand out is during the inquiry, Mr. Moser stated that he had put all the kids to bed around midnight. He then went into the room with his fiancee, and she was already asleep. He made comment that he thought it would be cute for all 3 of the children to be up on the top bunk, these being all minor children. The court notes also that upon inquiry, Mr. Moser advised, I did not hit her in the head, in the forehead, I did not. I could put that on everything. Then he states, I don't recall hitting them anywhere, but on their butts, hands, or their mouth. I did not close fist them, I don't do that. Inquiries made by Detective Cooley. Did you hit her anywhere? His response, last night? No, I didn't. Which is a little telling that they've been hitting him before, but not last night. And then he states, I believe I'm the only one that went into the children's room. I was the one getting up that kept checking on them before we went to sleep. I went in there probably 3 times. When he was asked to explain the bruises on the children, he explained, I disciplined them. I don't know how they got there. Mr. Moser gave a statement to the officers preparing the precinct investigation report. His statement was as follows. I was staying with my girlfriend at the time, Ian Hawkins, and I wasn't working at the time. I was in charge of watching 3 children while she was at work. On the night of July 1st, 2025, I used corporal punishment on all 3 children. That resulted in the death of one of the children there. I had a rough childhood. My mother had difficulty with drugs. My father had difficulty with alcohol. And he felt that he was abused as a child. He knows that what he did was wrong, and he plans to seek mental health treatment while incarcerated. The criminal background, there is none. Family history, he was born on May 16, 2022 in Brown County, Ohio, to Joe Ray Dean Rolfe of Kentucky and Terry Michael Smith Jr. of Manchester. Mr. Moser reported he currently resides in Manchester, has 1 biological sibling, with the defendant being the firstborn. He has 1 half-step or step sibling. His father has had interaction with law, and his mother as well, for their abuses of alcohol and or drugs. He was raised in Manchester, Ohio, mostly by his mother until his father took over, describing his childhood as unhappy with the history of being abused. With the belt, he reported being placed in foster care due to the parents being deemed unfit at that time. He was placed with his grandmother until his parents had custody back. He was never married, and states that currently at the time of this interview he was not in a relationship. He has 1 biological child who is 2 years of age, with the mother having custody. He reported never having any involvement with the Child Protective Services. He does not own any child support. He stated he has 3 close friends that he has contact with daily before being in jail. 2 have been in trouble with the law or engaged in criminal activities. He stated he has 1 acquaintance that he has contact with every other month that has been in trouble with the law or engaged in criminal activity. He also states he's never been affiliated with the gang. He completed the 12th grade of education at Eastern Brown High School, Southern Hills CTC. Stated he was suspended or expelled from school for fighting. He does not have any additional educational certifications. There is no military history. He rates his own health subjectively as good, but he does have some different concerns. Mental health, he's previously received mental health services through Shawnee Mental Health in 2021, but failed to complete that treatment. He was diagnosed with multiple mental health issues through Shawnee Mental Health in the year of 2021. He did state that he completed mental health services through Rulon Center in 2024. Reported he's previously been hospitalized for various self-harm issues. His substance abuse history, he reported that he first drank at the age of 15, would drink 12 beers a day, a fifth of whiskey, or a few mixed drinks. He reported that he would smoke marijuana daily from the age of 16 to the age of 23. He reported that he ate mushrooms 3 times at the age of 23. He previously completed substance abuse treatment through Rulon's Center 90-day program in February of 2024. He was at transitional housing through Reach for Tomorrow in May of 2024, but failed to complete the transitional housing. His employment history is a crew member at McDonald's in February of 2025, Captain D's in October of 2025, McDonald's in October of 2023, and Walmart as an associate in September of 2021. He reports having no monthly income or expenses. He does get support from his family, and which makes it difficult to meet all the financial demands. In regard to recidivism, whether he committed the incident offense while in community control, that does not apply. Whether he has a history of criminal convictions or juvenile delinquency adjudications, the court has noted he has no prior felony, criminal, or misdemeanor convictions. Whether he's responded favorably to sanctions previously imposed in adult or juvenile court because of his incarceration, he has not violated his bond. Whether he shows a pattern of drug and alcohol use related to the offense and doesn't acknowledge or refuses treatment, he does show a pattern of alcohol and drug use related to the offense, but he has not completed any of the treatment. Whether he shows any genuine remorse, the author of the report suggests that he does not. The court would join in that in regard to his interaction with the defendant throughout these proceedings. He scored moderate or 16 on the high-risk assessment system, indicating a moderate risk of reoffending. The reality of this is that when a system of justice and the public at large becomes desensitized to the constant tragedies we are exposed to, both nationally and locally, widespread suffering starts to feel routine, dulling empathy, and any urgency for change. Yet, harm to an innocent child thankfully breaks through that numbness. It shocks people and the participants in the justice system hopefully back into feeling, because it represents pure vulnerability violated. The court at arraignment advised the defendant, based upon the returned indictments, that he was facing 63 years to life of incarceration. The court recognizes the necessity for plea negotiations and rightfully would expect attention to detail in all cases, but especially cases of such gravity where a young child's life is abruptly and unjustifiably terminated. The court would be disingenuous to suggest that it did not suffer concern when during the change of plea amendments had to be made to correct oversights, albeit inadvertent. And hopefully those changes as well will be sought. We must recognize that while our minor children only compose 1/3 of our population, they absolutely compose 100% of our future. The stipulated sentence, while the court understands and accepts that the stipulated sentence is suggested to this court will not be following that stipulated sentence. This is a child that under the stipulated sentence, she would be turning 18 years of age, 3 years of age in 38 days. So we're 38 days shy of her 3rd birthday, which would have occurred on May the 1st of 2026. Under this agreement, that child, if there would have been the possibility of life, would not have even been 18 years of age at the time of release from prison based upon the minimum sentence. Therefore, the court, in considering the factors of felony sentencing, finds that only maximum sentences would suffice in regard to any assimilation of fairness in this case. Therefore, after due consideration, the court finds that the defendant is not amenable to available community control sanctions. In fact, there's mandated sentences. It is therefore ordered that the defendant shall serve a stipulated indefinite mandatory, does not stipulate, will serve an indefinite mandatory prison term in count 4 of 11 years to 16 and 1/2 years. And a prison term in amended count 8 of 3 years, which shall be served consecutive to the term imposed in count 4, and stipulated, again, strike stipulated, and a prison term in count 10 of 3 years, which shall also be served consecutive to the terms imposed in counts 4 and 8. For a total sentence of indefinite sentence, of 17 to 22 and 1/2 years. And all of that shall be served in the Ohio Department of Rehabilitation and Corrections. Because multiple prison terms are imposed on an offender for convictions of multiple offenses, the court may require and is requiring the offender to serve these prison terms consecutively. Because the court finds that consecutive service is necessary to protect the public from future crime and or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of this offender's conduct which caused the death of this less than 3-year-old child, as well as the danger he poses to the public. And the court also finds that at least 2 of the multiple offenses were committed as part of one or more courses of conduct, that being the continual abuse of these 3 innocent children, and the harm caused by 2 or more of the multiple offenses so committed is so great, so unusual, and unfathomable, that no single prison term for any of the offenses committed as part of the courses of conduct would adequately reflect the seriousness of the offender's conduct and the seriousness of the results, not only the physical results, the loss of life, but also the psychological results in the damage to these children by being abused by someone that they likely at one point in time trusted, but likely in the balance of their last few weeks of life, I doubt that they did trust based upon the constant, or what appears to be constant, harm to these children. You're notified, Mr. Moser, that it is rebuttably presumed that you will be released from service of the sentence on the expiration of the minimum prison term imposed as part of the sentence, or on your presumed early release date as defined in section 2967.271 of the revised code, whichever occurs earlier in time. You're also notified that the Department of Rehabilitation and Corrections may rebut that presumption described in Division B2C1 of this section if, at the hearing held under section 2967.271 of the revised code, the department may specify determinations regarding the offender's conduct while confined, the offender's rehabilitation, the offender's threat to society, the offender's restricted housing, if any, while confined, and the offender's security classification. The court's also notifying you, Mr. Moser, that if, as described in Division B2C2 of this section, the department at the hearing makes the specified determinations and rebuts the presumption, the department may maintain your incarceration after the expiration of that minimum term or after the presumptive early release date for the length of time that the department determines to be reasonable, subject to the limitations specified in section 2967.271 of the revised code. The court further notifies you that the department may make the specified determinations and maintain your incarceration under the provisions described in Divisions B2, C1, and 2 of this section more than one time, subject to limitations specified in section 2967.271 of the revised code. Further, you're notified that if you have not been released prior to the expiration of the maximum prison term imposed as part of the sentence, then you must be released upon the expiration of that term. Further, you're notified that the department will be supervised, that you will be supervised under section 2967.28 of the revised code after you leave prison, because you're being sentenced to a felony of the first degree. Your placement or transfer into a transitional control program permitted under 2967.26 and/or your placement or transfer into an intensive program prison under Ohio Revised Code 5120.032, both are specifically reserved for denial or notification that the Ohio Department of Rehabilitation and Corrections desires consideration of you for either transitional control or for the intensive program prison. You're notified that post-release control in this case is mandatory. You have mandatory post-release control of up to 5 years, but no less than 2 years. You fully understand? If you violate any post-release control sanction or any condition imposed by the parole board under revised code section 2967.28, the parole board may impose more restrictive sanctions, a prison term not to exceed 9 months for each violation, or a maximum cumulative prison term for all violations not to exceed 1/2 of the originally stated prison term as imposed. But if the violation of your post-release control is the commission of a new felony offense while under post-release control supervision, then you may receive a prison term of the greater or the larger of 1 year, or the time still remaining under your post-release control up to that maximum 5-year period, and that may be required to be served in addition to and or consecutive to any other prison term imposed for the new felony offense that caused you to be in violation of your post-release control. You are ordered to serve as part of the sentence any term of post-release control imposed by the parole board, as well as any prison term for violation of that post-release control. You're therefore ordered to conveyed to the custody of the Ohio Department of Rehabilitations and Corrections by the Adams County Sheriff's Department. You will receive credit for all days previously confined or incarcerated. It appears that would be 263 days. I believe that was calculated through March the 20th, so it would be 267 days as of today's date of March 24th, 2026. And you also receive credit for any future custody days while you await transportation to the appropriate state penal institution. Mr. Moser, you notified that you may be eligible to earn days of credit under the circumstances specifically defined in section 2967.193 of the Ohio Revised Code. You're also notified these days of credit are not automatically awarded, but they must be earned by you in a manner specifically outlined under section 2967.193. State, I believe, the report that I've received from the probation department suggests that there was no restitution because proudly the community paid for the funeral expenses. Is that correct?
That is correct.
Very well. The defendant is further ordered to pay a fine of $2,000. The defendant is further ordered to pay all costs of prosecution of this action, for which execution is awarded, as well as any fees permitted pursuant to Ohio Revised Code Section 2929-18A4. The Department of Rehabilitation and Corrections is ordered to withhold funds in the appropriate amount from the defendant's account to pay these limited financial sanctions as imposed. Under Section 2947.23A1A, if you fail to pay these financial sanctions or this judgment, or fail to make timely payments towards that judgment under a payment schedule that's been approved by the court, then the court may order you to perform community service in an amount of not more than 40 hours per month until the judgment is paid in full, or until the court is satisfied that you're compliant with the approved payment schedule. Under Section 2947.23A1B, if the court does order the defendant to perform community service in lieu of, in exchange for the non-payment of the financial sanctions, then the defendant will receive credit at a specified hourly credit rate for every hour of community service performed. It will reduce the judgment by that amount. The court specifically finds in the imposition of these financial sanctions, the defendant has the past, present, and future income ability to satisfy these financial sanctions. The defendant, at the time of arraignment, was 23 years of age. I believe he still remains 23 years of age, correct? The defendant will have a period of incarceration that he will be able to earn $17 to $22 a month while incarcerated. The court has calculated the fine annual cost, that would be approximately $10 of that per month. And so therefore, the court finds that based upon that income ability in state prison, as well as his prior employment history as crew leaders of various food and beverage, that he has the past, present, future, and income ability to satisfy these financial sanctions. There has been no bond posted for the court's consideration of return to surety for compliance or forfeiture due to non-compliance. The defendant shall submit to DNA testing pursuant to Ohio Revised Code Section 2901.07. Because the court has imposed the maximum sentences, and especially consecutive, that is now a final appealable order, and it's a mandatory appealable order. So there will be a mandatory appeal that will be submitted to the Fourth Appellate District Court of Appeals for further review. You must know, though, that if you cannot afford the cost to file that appeal, then you're entitled as a United States citizen to file that appeal free of charge. If you cannot afford the cost of any documents that we possess that you need to promote your appeal of this court's decisions, upon your request, or provide those documents to you once again free of charge. If you cannot afford the cost to hire an attorney to represent you effectively, as the court certainly believes Mr. Green has done in this underlying matter, then upon your request, the court shall forthwith or right away appoint an attorney to represent you, but you will be required to pay a $25 village council fee fund. I stress to you and I emphasize to you that these matters must be timely filed, the notice of appeal within 30 days of today's date. The court is on constructive notice that there is an automatic appeal because of the maximum sentences, but I would respectfully request, Mr. Ring, if you would, if you'll still please file a notice of appeal.
Yes, sir.
State any additional objections like that noted at this time?
No, Your Honor.
Mr. Ring?
No, sir.
Sir, as I believe this is your biological child, is there anything else you would like the state to bring before its attention?
Yes. I'm sorry.
You're fine, Counselor. Ms. Moser, is there anything else you would like Mr. Ring to bring before its attention?
No, Your Honor.
Very well. We're adjourned. Thank you.